A Supreme Court decision just came down that's making millions of gun permits obsolete. And if you're carrying right now, you might not even know if yours is still valid. In some states, people who have been carrying legally for years could wake up tomorrow and find out they're breaking the law without changing a single thing about what they do. Quick question before we continue. Are you subscribed yet? Because what I'm about to reveal could save you from accidentally becoming a felon. The crazy part is, most gun owners won't hear about this until it's too late. Hit that subscribe button right now, so you're not one of them. Seriously, do it before we go any further. Okay, so here's what just happened. The Supreme Court didn't actually end all gun permits, like some headlines are claiming, but what they did do is arguably more important. They fundamentally changed the rules that every single state has to follow when deciding who gets a permit and who doesn't a T. And this decision is forcing states across the country to rewrite their gun laws from scratch. Some states are scrambling right now to figure out what they're allowed to do anymore. The case is called New York State Rifle and Pistol Association versus Bruen. Now, I know that sounds boring, but stick with me, because this affects you no matter what state you live in. Here's the simple version. New York had a law that said if you wanted a concealed carry permit, you had to prove to the government that you had a special need for protection. Just wanting to protect yourself wasn't enough. You had to show that you faced specific threats that were different from what regular people face. Maybe you owned a business that handled lots of cash, or maybe someone had threatened your life. Without that special reason, the government would deny your permit, even if you had a clean record and passed all the safety requirements. The Supreme Court looked at this and said, no, that's unconstitutional. You can't make people prove they deserve a constitutional right. Imagine if you had to prove you deserved free speech before the government let you talk. That would be insane, right? The court said the same logic applies to the Second Amendment. If you're a law-abiding citizen who meets basic requirements, the government can deny you a permit just because they didn't think you need it badly enough. Now here's where it gets interesting. This decision didn't just affect New York. 6 other states had similar laws. We're talking about California, New Jersey, Maryland, Hawaii, Massachusetts, and until recently, the District of Columbia. All of these places had what's called may-issue permit systems. That means even if you met every requirement, the government could still say no if they felt like it. They had total discretion. And in practice, this meant that in some places, almost nobody got permits except retired cops, politicians, and people with connections. But here's the crazy part. The Supreme Court decision came down in June 2022, and we're still seeing the effects play out right now. States are passing new laws, trying to work around the decision. Some of these new laws might be just as restrictive as the old ones, just written differently. And this is creating total chaos for gun owners trying to figure out what's actually legal. If you're finding this helpful so far, imagine what you all learn in my next video where I break down the 5 sentences that protect you when cops ask about your firearm during a traffic stop. These are word-for-word scripts that lawyers recommend, and knowing them could be the difference between going home and going to jail. Subscribe right now so you don't miss it when that drops next week. Let me explain exactly what the Supreme Court said states can and can't do anymore. First, states can still require permits. The court didn't say permitless carry is required everywhere. What they said is that the permit process has to be shall issue instead of may issue. That means if you meet the objective requirements, the government has to give you the permit. They can't deny you just because some bureaucrat doesn't think you need it. Second, states can still have requirements you need to meet. Things like background checks, safety training, fingerprints, fees, all of that is still allowed. The court made it clear they weren't touching those kinds of regulations. What they struck down was the subjective part where officials could deny your application based on their personal judgment about whether you had a good enough reason. Third, and this is huge, the court created a new test that judges have to use when evaluating gun laws. They said gun regulations are only constitutional if the government can point to similar regulations that existed in American history, particularly around the time the Second Amendment was written in 1791, or when the 14th Amendment was ratified in 1868. This is called the Hot History and Tradition Test. Basically, if there's no historical precedent for a gun restriction, it's probably unconstitutional now. This historical test is turning into a massive problem for states trying to regulate guns. Think about it. How do you find an exact historical parallel for laws about carrying guns in places like airports or sports stadiums when those things didn't exist 200 years ago? Or what about laws restricting access for people convicted of certain crimes that didn't exist back then? Judges are struggling with this, and we are seeing courts strike down gun laws left and right because the government can find some dusty old regulation from 1820 that matches what they were trying to do today. Now, quick legal note, this is educational information, not legal advice. I'm breaking down what these court cases mean, but laws are different in every state, and your situation is unique. Always consult an attorney licensed in your state for your specific situation. I'm here to help you understand the landscape, but you need professional guidance for your personal circumstances. Let me give you a real-world example of how this is playing out. Take New York again. After the Supreme Court smacked down their old law, they didn't just switch to a shall-issue system and call it a day. Instead, they passed a brand new law that technically gives permits to everyone who qualifies, but then they added a massive list of sensitive places where you can carry even with a permit. We're talking about Times Square, all public transit. Most private businesses, unless they post a sign saying guns are welcome, parks, places that serve alcohol, and on and on. The list is so long that gun rights advocates say it is basically a ban by another name. You might have a permit, but there's almost nowhere you're actually allowed to carry. California did something similar. They already had a shall-issue process in the works, but then they expanded their sensitive places list and added new requirements. Now you need liability insurance to get a permit in some California counties. You need to provide character references. The application process is incredibly detailed. Critics say these states are complying with the letter of the Supreme Court decision while completely violating the spirit of it. And here's what most people get wrong about this whole situation. They think the Supreme Court decision means they can carry everywhere now without restriction. That's absolutely not true. Even in constitutional carry states, places where you done a T need a permit at all to carry concealed, there are still tons of places where carrying is illegal. Federal buildings, schools, courthouses, and often private property where the owner doesn't allow it. The Bruen decision didn't change any of that. It just said states can to make you prove you have a special need before they all consider giving you a permit. Hey, here's a crazy stat for you. Only about 8% of people watching this video right now are actually subscribed to the channel. That means 92% of you are at risk of missing critical updates when gun laws change in your state. Don't be in that 92%. Hit the subscribe button and join the community of informed gun owners who stay ahead of these legal changes. Do it right now before you forget. So what does this actually mean for you, practically speaking? Well, it depends entirely on what state you live in. If you're in a state that already had shall-issue permits or constitutional carry, nothing changed for you. You've been living under this system already. But if you're in one of those 7 jurisdictions that had may-issue laws, everything just changed. First thing, if you were previously denied a permit in one of these states, just because the issuing authority didn't think you had a good enough reason, you can reapply now. The old justification for denial doesn't exist anymore. As long as you meet the objective criteria, clean criminal record, proper training, whatever your state requires, they have to issue the permit. Second, if you've been waiting to apply because you knew you'd get denied under the old system, now's your time. The doors are open in ways they weren't before. But here's the catch. Don't assume it's going to be quick or easy. These states are processing a flood of applications they never had to deal with before. Wait times in some places are running 6 months to a year. And remember, states have added new requirements in response to Bruen, so make sure you know exactly what your state demands before you submit your application. Third, if you have a permit from another state, the reciprocity situation is getting complicated. Some states that never had to think much about recognizing out-of-state permits are now updating their reciprocity agreements. The general rule is that constitutional carry states usually recognize all other state permits, but may-issue states that got forced to become shall-issue are less consistent. Check your state's current reciprocity list before you travel. Don't rely on information older than 2023 because things are changing constantly. Now here's the part nobody's talking about. This decision is creating a wave of lawsuits challenging all kinds of gun laws beyond just permit requirements. Remember that history and tradition test I mentioned? Lawyers are using it to attack laws about magazine capacity limits, assault weapon bans, waiting periods, you name it. Courts are striking down laws that have been on the books for decades because the government can prove they have deep historical roots. Just in the past year, we've seen major gun laws fall in multiple states. Illinois' assault weapon ban is being challenged, and parts of it have been blocked. Magazine capacity limits in several states are facing serious legal trouble. Age restrictions on buying certain firearms are being questioned. The whole regulatory landscape is in flux right now. But here's what you need to understand. Just because a law is being challenged doesn't mean it's not currently enforceable. If there's a law on the books in your state, you have to follow it until a court officially strikes it down or blocks it. Don't be the test case. Donna T. be the person who ends up in handcuffs because you assumed a law was unconstitutional and decided to ignore it. Even if you ultimately win in court, the process of getting there can destroy your life financially and personally. This is critical. Laws are changing fast right now, like really fast. Subscribe to this channel so you are never caught off guard when a new ruling drops that affects gun owners in your state. I break down these decisions the moment they happen, so you know exactly what is legal and what is going to guarantee. Click that subscribe button now Let me tell you about the timeline going forward, because this is where it gets even more important. The Bruen decision was just the beginning. There are multiple gun rights cases working their way up to the Supreme Court right now. Some of them deal with who can be prohibited from owning guns. Others deal with where you can carry. There's even a case about whether the government can completely disarm people who use marijuana, even in states where it's legal. The Supreme Court's next term is going to be huge for gun rights. We are probably going to see more major decisions in 2025 and 2026 that reshape gun laws even further. This means if you're not staying informed, you could wake up one day and find out that something you've been doing legally is now prohibited, or vice versa. The legal landscape is shifting under our feet. Here's a hypothetical example to show you why this matters. Let's say you live in a state with a law that's currently being challenged. Maybe it's a sensitive places restriction that says you can't carry in parks. You've been following that law because it's on the books. And then suddenly a federal court strikes it down and issues an injunction. Now that law is unenforceable. You can legally carry in parks. But then the state appeals, and a higher court puts a stay on the injunction while they review it. Now the law is back in effect, and you can't carry in parks again. This kind of back and forth is happening right now in real time across the country. If you don't have a way to track these changes as they happen, you're going to get caught on the wrong side of the law. Maybe you end up carrying somewhere that S prohibited because you didn't even know a stay got lifted. Or maybe you unnecessarily restricting yourself because you didn't know a law got struck down. Either way, you're operating without complete information, and that's dangerous. Here's something that shocked me when I started researching this. Most gun owners get their legal information from friends, gun store employees, or random people on the internet. And most of that information is either outdated, incomplete, or just flat wrong. I've heard people at ranges giving advice that would land someone in federal prison. They mean well, but they don't know what they don't know. That must is exactly why you need to subscribe to channels like this that do the actual legal research and break it down in plain English. Don't be part of the 73% of viewers who watch without subscribing. Join the community of informed gun owners who get these updates first. Hit that subscribe button right now. So let's bring this all together. The Supreme Court's Bruen decision didn't end gun permits, but it fundamentally changed the rules. States can't deny permits based on subjective judgments about whether you need one. They have to use objective, shall-issue criteria. But states are responding by adding new requirements and restrictions, creating a complex patchwork of laws that's constantly changing. If you're a gun owner, here's what you need to do. First, know your state's current laws, not what they were 2 years ago. Second, if you're in a state that had may issue laws, look into applying for your permit if you want one. Third, understand that even with a permit, there are many places where you legally cannot carry. Fourth, never rely on old information or casual advice from non-lawyers. And fifth, stay informed as these legal battles continue to play out. The bottom line is this: we're living through the biggest shift in gun rights law in a generation. The Supreme Court has opened the door to dismantling decades of gun control regulations, but states are fighting back with new tactics. The only way to protect yourself is to stay informed and understand both your rights and your responsibilities. This information could literally expire after the next Supreme Court term. Subscribe now, because I'll be covering every major decision the moment it drops, explaining exactly what it means for you and what you need to do to stay on the right side of the law. Don't miss out. Click subscribe. Look, I spend hours researching these cases, reading through 100-page court opinions and consulting with attorneys so you don't have to wade through all that complexity. The least you can do is hit that subscribe button to support this channel and make sure you never miss an update. It takes 2 seconds, and it could save you from a decade in federal prison. Do it right now. Stay safe, stay legal, and stay informed. I'll see you in the next one.